Almost every junior has said this at some point of his or her internship. Sir, I've found 5 judgments. But that line itself reveals the problem. Because legal research in litigation does not begin with judgments. It begins with identifying the issue. Most juniors approach legal research in litigation like this. First, they collect the judgments blindly, then they highlight the paragraphs, and then carry the files to the court. But when the simplest question is asked by the court, like, what is the issue? Then they struggle to answer, not because it's a lack in the intelligence, but because it's a lack in the training. The reason why this approach fails in courtrooms is because courts are not looking for law. They already know the law. Courts are looking for answers, specifically 3. 1. What decision must be taken today? 2. What is preventing the court from moving forward? 3. Which legal principle will resolve this block? You must remember, in court, time, clarity, and relevance matters more than volume. Every legal research for litigation must begin like this. Before starting the research, you must find answers to these 4 questions. 1. What is the court trying to decide today? 2. What is the procedural posture of the matter? 3. Is this an interim stage, a final hearing, or a procedural listing? 4. What will help the court to take the next step? These set of questions define issue, and without identifying the issue, the research becomes guesswork. When issue-based thinking is missing from legal research for litigation, then seniors reject the research work, arguments get interrupted, and written submissions are written again and again. This happens not because the juniors didn't work hard, but because the work which he or she did was directionless. Legal research in litigation follows a simple sequence. 1. You should read the order sheet correctly. 2. You should identify what the court is seized of. Or, in simple words, what's the court's decision in taking up a legal matter or issue within its jurisdiction. 3. Research only to support one clear conclusion. And always remember, one judgment used properly is better than 10 judgments used or pasted blindly. So, that's all for lesson 3. But once you start researching with the issue in mind, something important changes, right? You stop collecting judgments for the sake of volume and start looking for what actually matters in a judgment. And this brings us to the next mistake most people make. In the next lesson, we will discuss about what really matters in a judgment, the difference between ratio, observation, and obiter, and why not knowing this leads to weak arguments even with good case laws.